Parliamentary cause list. Item number 1, pronouncement of judgment.
Only the operator. For what has been discussed above, this court finds no reason to interfere with the orders impugning the writ petition. Resultantly, the writ petition stands dismissed. No order to cost. You are gone by your own judgment.
Much obliged, Lord.
Well,
Any mention?
May I please, Lordship?
yes.
Item number 25.
Item 25.
25.
Yes.
Lordship, I am for respondent number 2 and 3. 2 and 3. Lordship, I need some time, Lordship. I need some time. My voice is not good.
Yes, you have a voice problem. At least come near the mic. You cannot hear you.
Lordship.
Sometime.
Yes, yes, Lordship.
Yes, yes. One prayer made by MSP Bhattacharya, Learned Council, appearing for the respondent number
2 and 3.
2 and 3. You are for the state. No
number
problem. You are for?
Respondent 4, 5, 6.
Okay. Just record this thing. List is matter after 2 weeks. Yes. Obliged to listen.
Lordship, I beg
Yes.
to mention item number 23, Lordship.
Yes.
I'm praying for 2 weeks' time here, Lordship.
23.
No problem.
No problem.
2 weeks on the request of the petition. Item 23. Yes.
Obliged.
May it please, Your Lordship. Your Lordship, I beg to make a mention of item number 22, Your Lordship.
Yes.
22, Your Lordship.
Who is for the respondent here?
Dear Your Lordship, we have already informed Your Lordship.
Private respondent.
Yes.
Your Lordship, since the conducting council is indisposed, Your Lordship, I pray for 2 weeks' time, Your Lordship.
Just inform the other side.
We have already informed.
Yes.
Your Lordship, my humble prayer, Your Lordship. In the meantime, Your Lordship, in this case, case record may be called for Your Lordship.
No, you are asking for adjournment. Why should we call for case record unnecessarily?
Because,
We'll see if required, then we'll call.
Your Lordship, because it is fixed for hearing today, Your Lordship.
That is okay. That is no problem. But then records, whether records will be needed or not, let us see.
Your Lordship, then I'll leave it to your discretion, Your Lordship.
Lordship, 3 weeks may be granted.
Lordship.
Just on the request made on behalf of the petition. This is a matter after 3 weeks. Yes.
Hello, Lordship.
Whether record is needed or not, we'll see at the time of hearing.
Your Lordship, as per the instructions, it is necessary, Your Lordship.
We'll just see.
Lordship.
Lordship, I would like to mention item number 16.
Yes.
Your Lordship, 3 weeks may be granted. This matter.
You will not object to that. He's happy to see it. Yes. Yes. 3 weeks. You are appealing for the respondent number?
3 and 4.
Yes. The other respondents are there. Yes. Yes. We'll have it after 3 weeks.
Deeply obliged, Your Lordship.
List of 3 weeks. Yes.
Your Lordship, I beg to mention item number 12, Your Lordship. We just received the written argument
I have
from
filed
the...
my written submission,
Your Lordship.
Item
Ki-
12.
Yes, Your Lordship. Kindly let this matter come after 2 weeks, Your Lordship.
The
You filed your, you have you filed
We
your?
just received.
They have filed. They have filed.
We've all
They have
filed.
filed.
Yes, Your
Myself, so I have filed, Lordship. It's completed. Everything is completed.
Okay. Okay. We'll just say on the prayer of the appellant, on the prayer of the petitioner, not object to the learned counsel of the respondent. This is matter after 2 weeks. Yes.
Your Lordship, similar prayer for item number 15, Your Lordship.
No objections, Your Lordship.
Kindly let this matter come after 1 week, Your Lordship.
Item 15. Here the union is party. This is what? Service matter?
Yes.
Yes, Your Lordship.
No objection.
No objection, Your Lordship.
2 weeks on the prayer of the petition. Yes.
Obliged, Your Lordship.
May I please, Your Lordship, I beg to mention item number 13.
Yes.
Your Lordship, I pray for 2 weeks' time.
Item 13.
Yes.
You are
Your
appearing for
Lordship. Respondent number 1, 2, and 3.
Cantonment board.
Yes. Your
Yes.
Right, for the petitioner, I have no objections.
Some of the request made by the respondent is not objected to by the learning counsel for the petitioner. This after
Respondent number
after
2 weeks.
After 2 weeks. Yes. After 2 weeks. Yes.
Much opportunity.
May it please your lordship.
Yes.
Your lordship, I beg mention item number 11. Your lordship, I humbly pray let this matter come after 2 weeks, as the conducting counsel is on a sanctioned leave, your lordship.
May it please your lordship, I'm appearing for respondent number 4 in this item.
No objection.
No objection, your
Sir,
lordship.
2016 matter. This is what hacking. This is a dispute with regard to hacking, nakmaship, or
Yes, your lordship. It's a boundaries dispute between
boundary dispute
three
between two hacking.
items.
Okay. Just on the request of the petitioner, not objected with the learning counsel, acting of the respondents. List this matter after 2 weeks. 2 weeks.
Yes, your lordship.
2 weeks. Yes.
Right.
Highly obliged, your lordship.
May I please, Your Lordship?
Yes.
Your Lordship, I want to mention item number 17. So I pray for 2 weeks' time.
Why 2 weeks time? Why you are praying?
So the conducting counsel is out of stations. Your Lordship.
No, item 17. Okay, on the request petitioner, list after 2 weeks. Yes.
Much obliged.
Please, your lordship, I beg to mention item number 24.
Yes.
24. I have no objection.
He has not made his prayer. Wait.
Yes. For
Yes.
2 weeks, your lordship.
For the appellant.
Yes, for
Yes,
appellant.
for appellant. Was it hard at some length? No. This
No, it has not been hard.
Okay. Okay, just on the request made on behalf of the appellant. Let's just matter after 2 weeks.
Yes, 2 weeks. 2 weeks.
Yes.
Much obliged, your lordship.
May I please your lordship? I beg to mention item number 20.
Yes.
Your lordship, the conducting counsel is out of station, so I pray for 2 weeks' time, your lordship.
Who is
Let this be the last occasion, my lord, because I have some objection. Because, my lord, in this case, what has happened on the basis of the FIR, my lord, my account has been frozen. And there is nothing in this FIR. It's a FIR filed by the younger sister against the elder sister, making allegations that the mother has given money to me. My lord, nothing, the FIR does not stand at all. Let this be the last occasion. I don't want to put my
we will
young
not
friend.
say anything about last occasion, but then let it be remain in this be implied. Will not. Yes, yes. This on the request. Your state is a party here also.
Yes, we are respondent 3, your honor.
State is the party.
Now your criminal petition, it's seeking quashing of a.
Quashing of the entire proceedings, FIR.
Okay.
There's no investigation at all. Nothing has happened.
The state is the main respondent.
Yes, ma'am. State is there.
Yes, on the request made on behalf of private respondent number so. This is met after 2 weeks. Yes.
Much obliged, your lordship.
Obliged.
May it please Your Lordship?
Yes.
Lordship, I beg to mention item number 21. Lordship, I pray for 3 weeks' time.
I'm for the respondent number 3, Lordship. I have no objection.
These are new matters, 25 matters. Okay. Just 3 weeks on the request of the petitioner. Yes.
Much obliged, Lordship.
Yes, Lordship.
Supplementary cause list. Item number 2.
May I please, Your Lordship?
Yes.
My Lord, in this instant writ petition, we've challenged the impugned select list of the DHC, my Lord, Juai, my Lord. My Lord, at annexure, my Lord, 7 page 20, my Lord, whereby 11 candidates were selected by the DHC, my Lord, District Selection Committee, West Jantia Hills, Juai, my Lord. My Lord, the advertise was issued in the year 2024, my Lord, white advertisement dated 11 November 2024, whereby 14 numbers of total seats were advertised for the post of sericulture demonstrator, my Lord. and out of 14, as per the roster system, my lord, 3 for the UR and remaining others for the reserved category, my lord.
UR means unreserved.
I am for the unreserved, my lord, general
3
category.
means UR means unreserved.
UR means unreserved, yes, general category.
You don't speak in code language. Code doesn't understand code.
My lord, yes, my lord.
I said UR, I am, so that is.
My lord, unreserved means you are candidate, my lord, yes, my lord. Then petitioner having all the prerequisites qualifications, undergoing the 15-month course under the government of Meghalaya, had applied for the same, and after that, my lord, petitioner was issued admit card, my lord, for the written examination, my lord. Thereafter, my lord, the written examination was held on 19 December 2024. My lord, in the written exam, as per the DSC rules, my lord, DSC rules, the marks, the cutoff marks should be set, my lord, should be fixed by the respondent number 3, my lord. But in this instant case, the cutoff marks were never been set, my lord. After that, my lord, the petition.
How do you say that?
My lord, as per the DSC rules 2014.
No, that is okay. Cutoff mark is to be set. But in the present case,
yes, my lord.
If your contention is that it has not been set,
no, my lord.
How? On what basis you say it?
My lord, the admit card was issued to the petitioner along with the other candidates. Then exam was conducted on 19th December 2024, my lord.
Written test.
Written test,
Yes.
my lord. Written test was conducted for 270 marks, my lord, under different subject heads, my lord.
Yes.
After that, result was declared, my lord. In that result sheet, they have displayed only the roll numbers, my lord. The candidate who successful in the exam, my lord,
Yes.
qualified the exam for written test. No marks has been displayed.
It's not required.
Yes, my lord. But before the exam was conducted, written exams, the cutoff mark should have been fixed, my lord.
No, that is okay. It might be fixed. Might have been fixed. How do we say it is not been fixed?
No, my lord.
You have any information on what basis?
No, my lord, there is no information, no notice on that.
No,
my lord,
that is not. It is
no
not.
order was issued by the.
Cutoff mark, if it is fixed, there is no requirement that it should be made known to the candidate until and unless somebody asks for it.
Yes.
Have you asked for it?
No, my lord. It is the responsibility of the respondent number 3, my lord,
Yes.
being the state, my lord, the entire recruitment has to be in consonance with Article 14 and 16, my lord.
Definitely.
Yes, my lord. The basic requirement of a recruitment process or recruitment method before conducting, my lord, is to fix the cutoff dates, is to set out the entire method of the recruitment. What will be the method, my lord? Like different stages of exams are there, my lord. So that is the minimum requirement under Article 14
that is for
and
the committee to
Constitution.
set. You see,
Exactly, my lord. But in this case,
it is depending. See, depending on the situation. Okay, the cutoff mark or the qualifying mark for 1 year may vary in the next year.
my lord is correct.
So it is set from time to time.
My lord is
Now, but then the thing is that if it is whether it is set or not set, I don't think that there is a requirement for the selection committee to inform it in advance to the candidate. Yes, if later on if then dispute comes, definitely they will have to disclose this.
My lord,
Anyway, okay, proceed.
my lord,
Proceed.
yes,
All right,
my lord.
All right, proceed.
Yes,
you
my
see, then some names where some persons they qualified in.
My lord, yes,
written.
my lord. At Annexure 4.
Okay, so you qualified in the written exam.
I qualified in the
Yes.
written exam. At Annexure 4,
Yes.
page number 17, the results of the written examination.
Yes. That is only the numbers are reflected there. That is not in order of merit.
Not in order of merits. What will be the number? What number had this obtained by the candidates?
That is okay.
Nothing
That is not in
displayed.
because this is half humor. This is not final.
Yes, my lord. Thereafter, my lord, another admit card was issued to the petitioner for the personal
Yes.
interview. Then, my lord, personal interview was conducted, my lord, on 9th, my lord, on 9th June 2025, my lord.
Okay.
The petitioner appeared before the personal interview, and accordingly on 10th June 2024, the results of the personal interview is declared, my lord. Kindly have
The
annexure.
personal interview or the entire selection? Was there a separate
My lord, no, after personal interview held on 9th June 2025, the results was declared, and
result
this is
for the
results
entire
along with the, my lord, merit list in order of merit, my lord. Kindly have annexure 7, my lord, page 20, my lord. This is the final select list of the candidates.
Yes.
after the recruitment process was completed, my lord. Total 11 numbers were selected, my lord, by the DSC, my lord.
Yes.
My lord, I challenge this, the final select list, my lord, because, my lord, yes, my lord, the entire selection method, the method of selection was not known to the petitioner, my lord. What is the process of
What is the
selections, my lord?
advertisement?
Yes, my lord.
What is the advertisement?
Yes, my lord. Annexure 1, my lord. Page 14, my lord. This is the first advertisement on 4th September 2024, my lord.
Yes.
After this, my lord, this advertisement was corrected and accordingly another corrigendum was issued on 11 next page,
Corrected
my
to
lord.
what extent? For what correction?
With
was made?
regard to the change of post, my lord, increase in the number of post, my lord. And Annexure 2 is the final advertisement, corrigendum, dated 11 November 2024, my lord. My lord, have, my lord?
Just a minute. Just
Yes.
So in this advertisement,
Yes, my lord.
the scheme of exam was not set out.
Not set out.
No way.
That is my
So
case.
see that whether there will be only written examination, will be written and oral and all those, nothing has been mentioned.
Nothing has been mentioned. But we find this thing, my lord, the process, the method in the rules set out by the government, respondent, state government in the year 2014, my lord. I have annexed the rule, my lord.
Yes. What is the relevant part of the rule?
My lord, yes.
Page?
At Annexure 8, that is the rules, page 21, start from
Yes.
Personnel and Administrative Reforms, Department, Government of
What
Meghalaya
is the
rules.
relevant part?
Yes, my lord. At page 27, my lord. Sorry, my lord, 26.
Yes.
Rule 4.5, my lord.
Declaration of result.
Results of written examination. Cut-off marks shall be fixed as per the benchmark/standard depending on the number of vacancies to be filled. That is the minimum requirement, my lord. That is not followed, my lord. And moreover, my lord, in the recruitment...
See, if you read it,
yes, my lord.
then you have to read it further. There is no requirement of disclosure of marks.
No.
After the written examination.
My lord, correct.
It says that
Seal cover,
after
my
declaration of results, the individual marks secured by the candidate shall be kept in sealed cover.
Seal covered,
So
my
you should read the second line also. You should not stop by reading.
No, my lord. I am not on seal cover. They can be, there is a rule, my lord. They can kept in a seal cover, my lord. But cut-off marks, what will be the cut-off marks? That is the minimum requirement.
Where is the requirement that this cut-off marks should be informed to the candidates in advance?
My lord, that is the minimum requirement that has to be, my lord, followed, my lord.
How come you are, where is the requirement that should be known to you? That should be made known to you. Just the reply on that. The law says about, you see, fixing a cut-off mark.
Yes, ma'am.
We understand that.
Yes.
But then where is the law which says that you should be made known to? How the candidate should be made known to?
My lord,
Before the exam is held.
my lord, that is not there in the rules.
So that is what the court is
My lord,
asking.
the basic...
If reply the thing correctly, see, do not go here.
Yes, ma'am.
If it something is there, say yes. If something is not there, not there. That will say like.
That is not there in the rule. Doesn't provide so, my lord. That that has to be disclosed.
See, even if you see that 4.5 further, if you see the result of written examination shall be displayed in the notice board in order of serial number and roll number, not in order of merit. Immediately after declaration of
Yes,
written examination, the total number of persons who have so and so. So that is the question of declaring result of written examination.
Yes, ma'am.
In order of merit is not there. It is only in the order of roll number.
Yes, in order.
Anyway, we'll issue notice. We'll just.
Yes, my lord.
Yes,
My
Mr.
My lord, I have a small objection on this. It's a very serious objection.
Yes.
Please have the ad one. The advertisement at page 14.
Yes.
Please look at the eligibility criteria with regard to the age in the third column. Age and relaxation as on 1/1/24.
Yes.
The upper limit prescribed here is 32.
Yes.
So this is as on 2024.
Yes.
The relaxation is only offered to the SC/ST candidates.
Yes.
Now let's please look at his affidavit at page 12.
At page 12, yes.
So upper age limit is 32. His affidavit is at page 12. He has declared as on June 25, his age is 38. This must have escaped the
But then
attention of the
once you
committee.
have issued me admit card,
But I would submit, my lords, he still has no vested right in this matter. He
that
has
is
no
a
vested
different
right.
issue. But then see, there is no problem with his candidature.
Lordship.
You have accepted his candidature.
No,
You
my lords,
have-
I would
you
submit,
have-
my lords,
you
even if
have-
they have done it, this would not, they
So
still have a right to
We'll
exclude
see
it.
it if that is discussing. But then we cannot say it. Right now, presumption is that he is otherwise eligible.
Lordship.
So far as the eligibility criteria is concerned, there is no difficulty with the petitioner. Result of the exam, we may see.
My
See,
lord.
it is your scrutiny which has allowed
Lordship.
him. Otherwise, you would have
it
rejected
must have
it.
escaped it.
No, I'll short reply to this query, my lord, by
Yes.
my learned senior. With regard to the age, my lord, the petitioner is well within the age eligibility because there is a government order is there, my lord. Those candidates who were undergone 15-month diploma under the government, my lord, were relaxed, my lord.
There is no pleading, my lord.
Mr.
No,
Sen,
I don't have
Mr. Sen,
because
come
he is
to-
well.
just come to the advertisement.
Yes, Lord.
Come to the tabulation. Just see further below this is application fee and
Yes.
all. Just see below this, you read it. What does it mean?
No age limit for candidates already in government service. Meghalaya government services provided they entered service within the prescribed age limit.
No, this further with cabinet approval. so
Further, with the cabinet's approval on 19th December 23 for condonation of age, the overage pass-out trainees are also eligible to apply provided they attain the above-mentioned diploma course. The condonation of age will apply only to this recruitment cycle and therefore they will not serve as a precedent for future recruitment in the same post.
his case is that he has
I am on
undertaken that training.
That is his oral submission, my lord. There is no pleading to that effect.
My
But
lord,
then he said that. Anyway, we'll just
I have passed
No,
all
I
the
have
tests, my
prepared my
lord.
defense on the basis of
Yes,
this
my
pleading.
see. I don't think that if it is the age difference which you are pointing out, if at all it is there, the SC would have allowed him to.
Yes,
appear.
my lord.
Lordship.
So once his candidature was cleared,
My lord.
I don't think that should be a no.
But I have
any more
referred to some
any
case
issue.
laws which say that even if this is the case, at a challenge stage, if this comes up, he would have no right at all
You
to
just see,
present
you
this.
obtain instruction, you see like
Well,
whether that 38 thing is correct or not. If you
Lordship,
see, if
I
you find
will.
that he is not eligible, then matter.
Lordship.
My lord, I have only one request, my lord.
Yes.
I have filed a miscase, my lord,
Yes.
because they have recommended for appointment, my lord,
Yes.
to those 11 candidates.
Yes.
At this stage, my lord, until further order, they should not make
Why
any
11
appointment.
cases? You are not concerned with 11 candidates. You are concerned with only 3 candidates, unreserved candidates. Others you have nothing.
Yes,
Have you made them party?
My lord,
No, nobody's a party.
my lord, they have, my lord, the reserve candidate were not selected. Only the, kindly see the, my lord, impugn order, my lord, at page page 20, my lord.
Yes.
Page 20.
Yes.
Page 20, Annexus 7, my lord. These are
First three is unreserved.
yes, my lord.
First 3 candidates selected therein are unreserved.
Unreserved, my lord. My lord, these candidates were recommended for appointment, my lord,
Yes.
by the DSC to the state government,
Yes.
to the post of Serical Administrator. My lord, at this stage, my lord, kindly, my lord, no further action should be taken on this,
No,
because
there is
otherwise
nothing,
my
no
writ
prima
will be
facie.
infructuous,
Second
my
of all,
lord.
you have not made them a party. What is the question of
My lord,
passing in?
they have not
Any
made
interim
appointment
order
yet,
will
my
affect
lord.
their right.
Lordship.
Any interim order will affect their right. You should have implemented them party.
No, my lord, they have not yet appointed, my lord, so no.
Irrespective of it.
If,
They have to be heard.
if you say that without appointment they will not have a right, then there is a question of staying.
My lord,
See, this is a basic sum, Mr. I do not know. If you give a legal approach, it's okay. You are asking for staying the select list.
yes, my lord.
That means the right of these 3 persons will be affected, and you have not made them a party.
My lord,
Right, Mr. S. Kasan, London Council appealing the parties, issue notice, returnable in 3 weeks. You will appear for all the respondents, Mr. Shen.
Lordship.
Mr. Shen appears for all the respondents. And hence, no formal notice, no further notice is called for. Mr. The learned GA shall obtain necessary instruction with the returnable list after 3 weeks. There is a miscase also.
yes, my lord.
This case.
Miscase, my lord.
You have not made them a party. What is the
My
question
lord.
of passing any order?
My lord,
Mr. S.K. Hassan, Learned Counsel for the applicant, and also Mr. S.N. Learned G. appearing for the respondents. Step by this application, the petitioner has sought for stay of, what is that?
Yes,
It is
my lord.
notice or impunity. This is a result, isn't it?
The result.
Yes, the result,
List.
my
It
lord.
is select list, isn't it?
Select
Yes.
list, my lord.
Yes.
Yes, my lord.
So for impute selected basis dated 10/6/2025. Concerning pertaining to the post of sericulture demonstrator. What is it? This yes, separate. Between selections is so and so of the district selection committee pertaining to the post of so and so so and so. Stop. The learned counsel with the applicant contents that the entire selection was done without following the norms of selection as laid down in the office memorandum bearing number, just see at page 22, dated so and so, in as much as no cutoff mark was set. By the district selection committee. For written examination. He submits that there is no disclosure of marks obtained by each of the candidates in the select list. And hence the same has been prepared. Same has been prepared arbitrarily. Stop. Mr. Shandran GA for the state, on the other hand, contents that the petitioner himself is not eligible to be a candidate in the selection process, in view of the fact that in view of the disclosure made in the writ petition showing his age. Yes, 38 years. Stop. Further contents this. Further contents that there is nothing. So from the contents that apparently there is nothing illegal in the selection made by the selection committee. Stop. Correct. Upon hearing the learned counsel and on perusal of the materials on record, it is found that though the petitioner has made a prayer for 10th of made a prayer for stay of select list dated 10th June 2025. Stop. None of the candidates mentioned therein have been made a party in this party in the writ petition as well as in this missing application. Stop. Since passing of interim order would affect the right of the candidate selected right of the selected candidate, it would be inappropriate for this court to pass any order in absence of their participation in the matter. Stop. In view of the above, prayer for interim stay is rejected. The Michigan application stands disposed of. Yes.
Obliged.
Hello.
Maybe change here, there, just little bit corrections.
Obliged.
Hello.
You should make them a party if you want.
Item number 1.
Hello.
Yes,
Lordship, this is a revision application filed against the impugned orders, whereby the application I filed before the appellate court for the substitution applications. So substitution application was filed, objection was not filed by the Contempt board, and I filed additional document during the course of our hearing that court asked to file additional documents, because here the question was legal heirs and legal representative. Whether I am the legal heirs or I'm saying I am the legal representative, I am representing the state of the deceased. But the court, I don't know, the court while passing the orders has not taken into consideration any of my submissions and the judgment which I have cited, as well as lastly court has said both the parties are absent. It means on the basis...
Where is that?
Paragraph...
Both the parties are absent means this matter was disposed of in your absence.
Yeah. Lastly, for page 41 says counsel for both the parties simply file hajra.
Where it is? Page 41.
Page 41.
Yes. What it says?
He said, counsel for both the parties simply file hajra. Even the submissions of the counsels also not appearing in the orders. And in case of the petition for substitutions, the court has to make an inquiry under Rule 5, Order 22, Rule 5. There must be an inquiry. Suppose I am a pleader, if somebody dies, being a pleader I am under obligation to inform the court that my so-and-so died. Under Rule 22.
Whether law mandates inquiry in every situation.
Inquiry in case of there is a dispute. If the court is not satisfied that I am not the legal representative, then court has to make inquiry. If the court finds there is no legal error at all, then Rule 4 will be applicable. The court has to appoint the commissioner who may represent the state of the deceased. But the court simply cannot dismiss the petitions without making an inquiry. Inquiry has to be made.
Order 22. Let us read Order 22.
Order 22, I file Order 22 because the proceeding has not got awaited because it is filed within time. Within time, 90 days, time is there. We file. Now, Order 22 will come to the Rule 5. Rule 5 says, where a question arises as to whether any person is or not a legal representative of a disease, the plaintiff or deceased with the defendant, such questions shall be determined by the court. This is very important. And provided where such question arises between the appellate court, before determining the questions, direct any subordinate court to try the questions and return the record together with evidence, if any recorded at such trial, its findings, reasons thereof, and the appellant may take the same into consideration in determining the questions.
When this Order 20 Rule 5 comes into play, at what situation? It is not that this comes into play in every situation, isn't it?
Not in this. Suppose if it is simply allowed, if the court says that I am not the legal representative, I have nothing to show.
See, if it happens that your application is contested, then the question comes. Question means like it gives rise to an issue. Assertion and denial. You come, you say that I am the legal heir. Somebody else says no, you are not the legal heir.
That is the thing.
That is the question we see. But then, does it mean that just because there is no existence of situation as contemplated in Rule 5, the court has no power to reject your application?
No, court has to reject the power. Suppose if the court has to give a findings based on the evidence, based on the documents. But in the instant case, I file additional documents also to show. Can you see the Rule 2?
What are the additional documents you filed?
Additional documents that I am the one who is representing the estate, the property of the deceased. Then Rule 2.
Where is that additional documents? Where are those additional documents? And what are those which have not been taken into consideration?
That was not at all discussed in the.
Yes. Who is appearing for the other side?
SP Mohanta. In fact, SP Mohanta, he is on leave, but he told me that if the notice can be.
Okay, we'll issue notice. We'll just yes, Mr. Avram.
He's on leave. He's out of station. Yes.
So we'll issue notice, or you will accept notice on behalf of the cantonment?
Let notice be issued. I cannot accept notice on him.
Revisional jurisdiction scope is
very limited.
Very less. Very limited. So until and unless you show
yes,
that there is a jurisdictional error, there is no question of it.
Or improper exercise of power.
That also is jurisdictional error. Jurisdictional error doesn't mean that it is only territorial jurisdiction or pecuniary jurisdiction. There are several aspects of jurisdiction.
115.
Okay, let's hear Mr. Qureshi, Learned Counsel for the petitioner. Issue notice, returnable in 3 weeks. The petitioner shall take steps for service of notice upon the respondent number 182 leading to this list after 3 weeks. Yes.
Hello, Bajaj.
I'd move to
Yes.
We have taken steps upon respondents 4 to 8 and 12 to your lordship.
May it please your lordship.
Yes.
Lordship, I will be entering appearance on behalf of the respondent number 12, the Legislative Assembly.
You'll appear for 12. What
Yes,
about
for
5?
12.
428, Your Lordship, is left.
4 to 8, there is no appearance.
No, Your Lordship. It's the MIDC.
So, but then they have been served.
Yeah,
The office note indicates that they have been served.
they have been served.
There is no appearance. What about respondent number 5?
428, it's
5.
No.
oh, sorry. Your Lordship, 4 is the chairman of MIDC, 5 is the managing director.
So, but then see the office note. ID card not received back from respondent number 5 and 12. See, 4, 6, 7 and 8, the ID card has been received. But then 5 has not been received.
Your Lordship, we have. Your Lordship
Have
will
you
file an.
verified the office notes here
No, Your Lordship.
of the case record? You should have verified it. See, so far as 4 to 8, except for 5, others are served. Now 12, Mr. Sulai is entering appearance. So what about number 5? He may be an official of the same concern where 4 to 6, 7, 8, 4, 6 and 7, 8 they are serving. But then you verify the status of 5?
Your Lordship will file an affidavit as well.
That is better. That is better. Okay, just just so office note indicates that notice upon respondent number 4, 6, 7 and 8 have been served, have been affected. 4, 6, 7, 8 and 12. 4, 6, 7, 8 and 12 have been affected. Just say Mr. Andy Shulai. You will be here as a senior
Lordship,
advocate.
senior counsel, Your Lordship.
Yes.
Assisted by Mr. R. Colby.
Yes, Mr. Andy Shulai, London, senior counsel, along with like so and so, appears for the respondent number 12. Stop. See, this is something you have dictated wrongly. You just say the office note dated 12/6/2025 indicates that report of service upon the respondent number 4, 6, 7 and 8 has been received. Okay. However, there is no appearance. However, there is no report of service of notice upon the respondent number 5. Stop. Then you say Mr. Shulai, London senior advocate, along with so and so, enters appearance with the respondent number 12. Okay. Then you say the petitioner shall verify the status of of service in respect of respondent number 5 and file an affidavit to this effect. Within how long you will file? How long will it take to file an affidavit with
Just
respect?
a week's time.
Within 1 week.
1 week.
Okay. At the top, you just say so and so is present with the petitioner. Mr. Sinkon is for the state. No, but then here in this case, the first one, respondent number 1 to 3, your name is there, and Miss E.V. Pasa is there for 9 to 11. 196. In WPC 196. That is what has been recorded in the last order. So just so and so are present at the top. You just say, okay, and then second part will that order. Okay. Yes. It will be list after
After 2 weeks, Your Lordship.
After list of 2 weeks. Yes.
Your Lordship, item 4 is connected as well.
Same, Your Lordship.
Let us see what is the.
But only we have to have.
Yes.
You see.
Here, my lord, only difference is the petitioner has retired.
Anyway, but then so far as service is concerned, this will be same order, ditto same order. Here also 5 years not been received. So you verify.
Your Lordship.
Since you have made him a party, so notice has to go.
Your Lordship.
Same order.
Lordship, yes.
Item number 5.
Obliged.
Yes, my lord. This is for reconstruction of the pension book, that is the service book of this petitioner.
Yes.
So, my lord, here that since there's a transit from in 2002 from Tura to Ampati, there seems to be they've misplaced his service records. We may need time to reconstruct it, to reconstruct the service records.
But then if you take too much time, he's suffering because he's a.
Definitely, we regret the inconvenience caused to him, but we're making all sincere efforts to.
Anyway, you have not filed your affidavit, is
Not
it?
yet, not yet.
Whatever you do, you file an affidavit.
Yes, my lord.
Okay.
Yes, my lord.
And then
Now that I have received all
Yes.
the comments.
And you will not file an affidavit, I think, Ms. Pasa? No.
I'm yet to receive instructions.
Yes. This is Accountant General. You are only the dispersing officer. Okay. We'll give a wish. So long they cooperate. you see.
Lordship.
Without a fight, if you get the fruit, then it is good. Yes. Just Ms. Oibang, learned G, appearing for the respond number 1 point, praise for grant of for the 2 weeks time. For praise of grant of 2 weeks time for filing
Yes.
counter affidavit.
We'll file. We'll file.
Counter affidavit.
I'll bring the papers and records saying that we are making sincere efforts. A short affidavit.
Prayer allowed. List after 2 weeks. And then before that, just say Mr. Sangma, Learned Council present on behalf of so and so, and also so and so. Miss Pasai Kasa, Learned Council present on behalf of person number 5. Then you say Mr. So and so. Okay? Yes.
6.
Must press, Lordship.
Yes.
My lord, I also need time to file a counter here. They have approved his pension, but I need time to file.
My lord, we have no instructions of receiving the amount till date, my lord. If they
That's all right. If they let her obtain instruction and file an affidavit.
Yes, we have received the comments. We'll be filing.
Okay, just this is also aspect for by MS Sudan, Learned Council. Granting J paying for the respondent 1 to 3.
My lord, I'm sorry to to interrupt. We have received instructions that we have approved his pension. His pension will be released soon. That's
So
all.
you
I don't
bring it on
think.
record. You bring it on record.
Your Lordship, we're yet to receive instruction to you.
No, that is all right. Your disbursements will come later. Once let them finish the formality, then
bring it on
you-
record.
Only after we receive the papers.
you do one thing. You bring it on record. Okay. So they will also have get a copy.
Okay.
Yes. Yes. Aspect for by so and so. Learned Council GA appearing for the respondent. 2 weeks time is granted for filing counter affidavit in the matter. Yes.
Deeply obliged, my lord.
Supplementary cause list. Hearing. Item number 3.
Oh, acha, yes.
May I please, Your Lordship?
Yes.
By an order dated 17th of June 2025, the Honorable Court was pleased to allow the revisioner to implead the necessary party, which is the complainant, Your Lordship. Now, Your Lordship, we also pray, Your Lord, that June, on the 4th of July, that the concerned party may be present.
Just in the miscase, this will be the miscase. 52 of 2025. Just in terms of order dated 17/6/2025. He is to be added where? Your petition doesn't say where a person should be added. What is the prayer? Just see.
For
What does it
pleading the applicant as respondent party.
Where? In which case?
Oh, in which case?
Oh yes, Your Lordship, via the missed case application, 2025, Lordship. It says in the prayer that under the premises aforesaid, is humbly prayed that Your Lordship may be graciously pleased to allow the petition applicant in adding and pleading the complainant / victim as a respondent party.
Where? Should be added where?
केस नंबर लिखा है, लेकिन लिखा नहीं प्रेयर में, वो बात को पूछा।
Yeah, you do not even bother to mention the basic things.
The case number is not mentioned.
Nothing, nowhere in the petition. Even on the cost study also doesn't say there is an application for implement of such and such in so and so. What kind of application you file? And if court goes on entertaining these things, then this will be perpetuated. This will become a practice.
Your Lordship, the conducting counsel has only instructed me to
There is no excuse. You have stood up for this thing. Do not blame the conducting counsel. Once you stand up before a court to argue a matter, that becomes your responsibility. You see.
Correct.
Now, if a party gets this petition, the party will not know where the party is sought to be implemented. Obviously, if we pass an order issuing notice here, you will take steps, you will supply this copy of this thing to other side will not know what is this. The party will not know she is sought to be added where. See, there is no shortcut in legal work, there is a problem. And this is what has been adopted here nowadays. Nobody has botheration about the legal requirement, what the law requires.
Correct it.
See, Mr. Kharmi, the client suffered, the party suffered, that is the main thing. Especially when a person is in jail.
In jail.
So what is to be done?
Withdrawn करेंगे.
Just say, Ms. Kisama, just say this is an application for implement of the implement of the respondent number 2. As a party respondent in criminal division petition number 9 of 2024. Hi, Mr. Sensor, just give your name. Issue notice. When? How many days? Notice is to be made returnable within how many days?
Lordship, the next hearing is on 4th of July.
Why 4th of July?
So as per information given by the council, Lordship.
Just after 2 weeks. Reduce. When is the main case coming up?
Main case.
4th of July, some.
4th July. Okay, make it returnable on 4th July. Stop, Mr. Karni. Appears for the respondent number 1. Stop. The petitioner shall take steps for service of notice upon the respondent number 2 within 24 hours. You take steps for within 1 day. You understand?
1 day.
But it's not here. Your Lordship, if it's possible within 3 days.
Why 3 days?
By dusty service.
No, you want it to be returnable on 4th. So today is what date?
Do you want it to come
24th
forward now? So you take step. Take step. to
Today is
1 day
24th. What is the
also.
time? Hardly 10 days time.
For
If
taking
you take
step
3 days
1
in
day
taking
also will
steps,
do.
then how a thing would be, notice should be served? Within 2 days, make it 2 days. Within 24 hours, make it 2 days. Then list on 4th. Yes. Oh, it's already made returnable. Just list accordingly. Yes. This is something we
1
do
day
not do
also
in
will
a
do.
callous way of doing it. Yes.
The list, item number 7.
My notice matter relates to CMJ University. I filed the application for striking out the dissolved university.
Yes.
And second application I filed for impleting the joint secretary who has been empowered to oversee the dissolution process. And the additional affidavit bring on record the notification given by the government only.
How many miscases you filed?
Two miscases we filed.
143 is about?
It's not there in the list to be.
Well, one miscase for him.
One is 143. One is 143, one is 144. What is 143? Okay, 143 is striking out.
Striking out.
Yes.
Respondent number 5, 6, 7, 8, 9, and 10.
Yes.
From the area of parties.
Lordship will file objection, Your Lordship, because Lordship kindly have the writ petition.
What is the gist of your objection?
Lordship kindly say writ petition. Lordship kindly have writ petition 196. Lordship, respondent number 6 is still alive, Your Lordship. The CMJ Foundation is still there, Your Lordship. The university may have been dissolved, but the foundation is still there, Your Lordship. And today, a writ petition has been filed by this, Your Lordship. It was listed before
What is the stand taken here about the foundation? They what
Lordship, they
for striking out. What is the ground taken?
Lordship, the only ground is done. Lordship, can you have at paragraph 2 at page 8?
Yes.
That during the pensive instant repression, the Honorable Supreme Court, by judgment order dated, affirmed the order censor passed by the competent dissolving the CMJ, the appellant case of the to allow the to produce a copy of the judgment. That recently it has come to the notice that in pursuance of the decision, the respondent has appointed the joint secretary. This is correct, Your Lordship, to oversee so and so, Your Lordship. That is the only thing, Your Lordship.
No, but then why this they have been struck out? That is, what is the ground?
There is no crown, Your Lordship. Where is the crown?
Mr. Sangresho, there is not even a single apartment
Where
that
is the
they are
crown,
no
Your
more
Lordship?
required.
It's very much a necessary part, Your Lordship.
There is nothing in face of it should be rejected. Just show us one apartment.
Rather, the state should be struck off from the proceeding of Article 226, Your Lordship. The foundation is still there, Your Lordship.
Nothing. You do not say that these respondents are no more needed.
I said they are very much a necessary
The
part, Your
university
Lordship.
has been dissolved by the governor.
No, that is where is that specific? There is nothing.
Supreme Court has already.
That is
upheld
all
the
right.
resolution.
There is not even a single averment in your application that in view of the Supreme Court judgment, these respondents are not needed.
Well, that one.
That not even a single averment. Yes, Mr. Shula, you file your objection. Just say this.
Well, that Supreme Court decision, my lord.
No, we are talking about your petition.
There is
Application,
no
my
ground.
lord.
What is the
Your
ground?
petition, your
My
miscase
application.
143. Come to the body of your miscase and just show.
Miscase. Para 3.
Yes.
Kindly see para 3.
Yes.
We have referred to Supreme Court decision.
That
And
is
last
all
time
right.
we have given copy. Copy
It
of the
is-
Supreme Court is already part
Where
of
is the statement that this, in view of the appeals court judgment, these things are not
My lord,
needed?
para 3. Kindly see para 3.
Yes.
My lord, recently it came to notice that in pursuance of the above decision, and the Supreme Court might be the respondent state has appointed the Joint Secretary Education, Governor Meghalaya as Administrator of CMJ University, oversee the winding up process of the opposite dissolved university. And accordingly, public notice that is such was issued by the said such and such. In short, since the above university being dissolved as affirmed by the Supreme Court, the said university has ceased to exist, and as a result, the entire process for winding up the dissolved university has been completely taken over by the respondent state.
Yes.
And filed this application. So we have given the crown.
You have not seen that in view of C is nothing. It is not required that this respondent to continuation is
crown,
written.
Lord?
My lord, in that
You have left everything on implication, so nothing express.
my lord,
It's a groundless application, Your Lordship.
if lordship has
You
not,
file objection, Mr.
my
Sula.
lord, if it is not required, it is good
No,
for
no,
me not
Mr.
to
This
strike out
is
also.
this is something is not at all expected. There is nothing.
The Supreme Court decision is we have referred to, man. And it
See,
is not part of the
this,
record.
This application has to be specific, isn't it? You file a separate application.
It will be good for me, my lord, if the party is not strike off. Lordship may proceed on merits. I'll proceed.
Let us see, since you have filed an application, it has to come to a logical end. We will give him opportunity to file an objection. Just say 143.
This is 143.
Not Mr. So-and-so.
142 Gaday
Senior
for
counsel assisted
impleading.
by so-and-so. For the applicant.
Connect for impleading.
Two missed cases are there.
Stop. Just a minute. Let us pass order one by one.
Madam.
Yes. By this application, the applicant has sought for. The applicant has prayed for striking out. The applicant prayed for striking off the respondent number, striking off the respondent number 56789 from the array of parties. In the writ petition number also you have not mentioned. In which writ petition you want? In writ petition number 186.
196.
You see, in your prayer you have not said. You just only writ petition, but then there is more than one writ petition. This is you do not know. Anyway, so the parties, what is it? Striking off the respondent number 5, 7, 5, 6, 7, 8, 9 and 10 from the Mr. Sulai 100G 100 AG appearing for the respondent number 1, 2 and 3, 4. Number 1.
Just a minute, Lordship, please. 124, Your Lordship, yes.
Yes. Please forego some time for filing an objection. Prayer Lord, how long will it take?
Let it be 2 weeks, Your Lordship.
Yes, Prayer Lord, this doctor, 2 weeks. What about the other respondents?
The one is appearing. So the university has been dissolved.
Lordship notice will have to go also.
No, but then we have
University has been
to,
dissolved.
since you have made them a party, so we have to formally.
And here, madam, in the main petition, they are not appearing since it is dissolved.
That is okay, but then since they are
Lordship,
party,
kindly
what is the
see,
solution?
kindly see number 8.
It doesn't require for.
Kindly see number 8, Your Lordship,
In
by
the main
name.
petition, they are not contesting.
No, just tell us what is the solution in such a situation.
But if the state wants, my humble
This is a new application, isn't it?
Madam,
So
if
the
state
notice
wants-
of the new application has to go to them.
If the state wants to file an objection, they can file it, madam.
Lordship,
But with
it
regards
is
to the
all right,
remaining one, remaining one,
You are
remaining one, my
talking,
lord.
please say about respondent number 5.
Madam, notice is not required to go. Because in the main petition, my lord, they are
So
not
you should not have
contesting.
implemented them.
But
But
since
then
they
once
are
you have
already-
implemented them,
Unless they are strike out
6
from the,
to 10, Lordship,
until
will
unless their name is strike out
require.
from the petition. Therefore, we admit them as a party.
huh?
They are a party in the main petition.
Yes.
So until unless they are strike off, my lord, it is the.
So that means so long they are not struck off, they are remain in this thing, petition, isn't it? So notice has to go to them.
Well, if we can take steps, but they are not contesting the
There
main.
is no other option.
They are not contesting the main petition.
It's all right. But then
It will be a futile
but then-
exercise. I can take steps and there is no harm. If Lordship desired, you should notice.
Publication in the newspaper also is one of the mode of saving notice also, Your Lordship.
once you choose them to make them parties,
Yes.
so
And Lordship,
it is
kindly.
not that you have not chosen to make them parties, saying
We
that
will
by
say
making a
the same
statement,
address. The
you
same
have not
address.
made any statement saying that they are not contesting the writ petition, so there is no requirement of making them party.
My lord,
So you have not made this thing. So you have made them party. You have chosen to make them party.
I
You
can
say
take
you
steps.
do one thing, you say another thing.
I can take steps. Otherwise, the record reveals that they are not contesting.
Though we know that taking steps also
Lordship,
would be
they-
meaningless, but even
The
then,
address, Your Lordship. The address, Your Lordship, we can have from this newly filed writ petition, Your Lordship. This is the address, Your Lordship.
that is for him to take care of this, how they are served or not. Okay, Mr. Sulai.
Lordship.
So long somebody is made a party.
Number 8, Your Lordship, is by name.
Just after this, after the first part, Okay. Okay. Then you say, insofar as the respondent number 5 to 10 are concerned, it is a submission of the London Senior Council that the said respondents are not contesting the same are not contesting the main writ petition, and hence there is no requirement of serving a notice upon them. Stop. Just since the petitioner, since the applicant has chosen to implement the respondent number 5 to 10 in this application. It becomes how many applicants are there?
Another application, Your Lordship.
No, how many applicants are there? It becomes
29 applicants are there. They are the
it
petitioners.
becomes incumbent upon them to take steps for service of notice upon the said respondents. Step. The applicant as such shall take step for service of notice upon the respondent number 5 to 10 within 2 days. Just down below. List as ordered above. List as ordered above. Yes. Then next is 144 is what is to be done?
With regard to, my lord, the implement of the Joint Secretary, the Administrator of the same university, my lord.
144.
Yes, Mr. Sulai. What you
Lordship,
say?
in this also we will file objection, Your Lordship.
There also this respondents are there.
Lordship.
No, their university is not a respondent.
University is not there.
So you will represent all the things.
Lordship, yes.
Okay, just say hard Mr. So and so, or a senior counsel assisted by so and so. Then just say by this application, the petitioner has sought for implement of the whom you have sought.
Well, the implement of the Joint Secretary who has been appointed as Administrator.
Where is this? Where is he a party here?
He's not a party,
Your Lordship. But the state is there, Your Lordship.
No, but then in the miscase.
Miscases.
Miscase is not required to marry party. Where is the details where you have said that whom you want to, which paragraph?
Lordship, same, Your Lordship. Paragraph 3, Your Lordship. And paragraph 4, Your Lordship.
Paragraph 4, Lordship.
This job was assigned to him by virtue of the judgment of the Honorable Supreme Court, Your Lordship.
Achha. I do not know that is what is. This is assigned by the Supreme Court.
Lordship, yes.
But then he will stand automatically. What is the problem?
That is why, man.
Anyway, since you want to file an objection, you file an objection. For what you said for the administrator of CMG University, Joint Secretary Education Department, Government of Meghalaya, Shillong, as respondent number 5 in the petition number 196 of 2014. Here your prayer is in detail. In the other petition it is very clear.
The trick petition, yes. You could have mentioned it on.
So other, since you are striking out, you said forget it, just do it anyway, isn't it? Stop. Paragraph. Mr. And they should not knowledge that AG appearing with Mr. Khan. AG appearing with Mr. Khan for the respondent number, for the state respondents. Yes, praise for grant of some time for filing an objection in the matter. Parallel, list after 2 weeks.
If I may submit, Your Lordship.
Yes.
Lordship, in fact, Your Lordship, in fact, these two writ petitions can't be disposed of, Your Lordship, because by virtue of the judgment of the Honorable Supreme Court, Your Lordship, the administrator had been appointed, Your Lordship, and claim and objection had been called, Your Lordship. If Lordship kindly come to the additional affidavit filed by the
This we will see only after these applications are disposed of.
Exactly.
Otherwise, these orders
Fail to
are not
understand.
necessary. If you say that the petition can be disposed
Exactly.
of, if you dispose
They
it off,
can-
then you have
they-
to say that this application has
they
become
can approach. They can approach.
Once you come, you see that scope will always be there for you to say it. So you want to say that the grievance which they are raising here,
Yes.
they should raise it before.
They should raise before the
Yes,
administrator.
it appears to be a valid this thing,
Lordship,
contention.
Lordship, I
Let us see.
think-
Let us see what happens. For you, that opportunity will remain.
It's
If
very difficult to
that
understand.
remains, then we will do that. What is their grievance raised here?
Lordship, regarding the compensation, Your Lordship.
For?
Lordship, they want to have the claiming the refund of the fees, whatever
Okay.
fees paid by
And
them.
what duty is entrusted to the administrator?
Lordship, I kindly see the judgment of the.
No, what is the, in short, just tell us. You do not take us to all those things. Since we have passed already order, so we are not going to.
Lordship, I'll just.
Oh, in the writ petition? You just say list after 2 weeks. In the main writ petition, okay?
Open,
That is
Lordship.
196. Okay.
I'll place it, Lordship, on the next.
Yes, that is better. If you say that this is the grievance raised here,
Lordship, yes.
can we address the definitely?
Can be addressed, Your
Yes,
Lordship.
yes, okay. Okay.
Because in that writ petition also,
Yes.
filed by the foundation, Your Lordship, they also want desire that before any action is taken by the administrator, they are required to be heard. That will bring, Your Lordship, all those will bring it.
Can you?
My
If
Lord,
you
we
say that,
kindly-
we will record your submission on this.
My Lord, we kindly take on the additional effort on record. We are fine on the same thing.
You are talking about this case?
Yes, in this.
Forget it, we will have it after next day, on the next
Lordship.
Where?
Highly obliged, Your Lordship. Then same, Your Lordship. Same order will follow. Just simply adjourn, Your Lordship.
In order passing this WPC
Okay.
190.
Just say, just say.
Simply
List of
adjourn,
list
Your
of
Lordship.
activities. Just say list of activities. Yes.
Oblige, Your Lordship.
That is already probably tagged. It just say list of activities. Yes.
Please, Your Lordship. This is an application for quashing of criminal proceedings pending before the trial court.
Yes.
Sir, I'm seeing some accommodation today. My senior is on his legs, man. Some other day.
In any.
This matter was heard earlier, my lord. but I
What heard matter?
Perhaps it's forgotten. The matrimonial dispute within the family.
It happens, you see, like many matters we hear.
My
And
lord,
then
once Lordship hears again, perhaps Lordship will remember.
there is a matrimonial matter.
Matrimonial matter. Certain technical aspects have been raised regarding issuance of process.
When?
After 2 weeks, man. 2 weeks.
I have no such objection.
No problem. Okay. Just on the prayer of Mr. Amy Ahmed, under counsel. One prayer made by Mr. Amy Ahmed, learned counsel appearing for the respondent, comma, not objected to by Mr. Gautam, learned counsel appearing for the petition, listen not after 2 weeks. Yes.
No, sir.
18?
I think we'll have. Yes. This is already lunchtime. I think. Yes.
This is also a petition on the 482.
You intend to take it up. If you want to take up, then we'll sit after lunch.
Well, I think she needs. She's praying for accommodation.
Is this a matter where we call for the record?
No, my lord. That is a different. Here, my lord, directors have been arraigned as accused, and my case is that directors are not liable in such case. I have judgments of the Supreme Court also. We can hear it next week.
Next week there may not be.
Then, my lord, whenever court is free, according to the roster of the court.
After 2 weeks.
2 weeks, Lord.
On prayer might just say on behalf of Mr. Manager, not object to by Mr. So-and-so, list after 2 weeks. Yes.
Obliged.
19?
How many matters are there? Yes, ready.
Let this matter come up after 1 week, Your Lordship.
After 1 week may not be possible, it has to after 2 weeks then. One prayer made by. Raju? Yes, madam, it will come after 2 weeks. She is asking for time.
Lordship.
Yes. I just say on the prayer made by Ms. Ajam, Honorary Council, appearing for the appellant. This is matter for 2 weeks. Yes. There is no other matter.